In this subunit, we're going to discuss two provisions of the Statute of Frauds, the marriage provision and the executor provision. All right, let's take a quick look at our mnemonic device to help us remember my legs. These are the contracts that are within the Statute of Frauds, my legs. Marriage, year, land, executor, guarantee, and sale. So in this subunit, let's focus on the marriage provision and the executor provision. Any contract where the promise to marry or marriage is a consideration for the contract, this contract is within the Statute of Frauds. In other words, it must be in writing. If it's not in writing, it's not enforceable. So this is an example, right? It seems very ancient, but this is what we're looking for. If you marry my son, I will give you a 10% stake in our family business, right? We have marriage as a consideration for the promise. I promise to give you a 10% stake in the business, right? Or maybe a more modern example is the prenuptial agreement, where parties, before they get married, they're going to determine how their marriage is how they're going to deal with the dissolution of their marriage, right? How they're going to separate the property, etc. This is not the type of promise we're looking for, where Pat and Marion, a couple in love, promise to marry each other. This type of contract is not within the Statute of Frauds. And indeed, this probably isn't even a contract, because the parties intend to have social consequences and they intend not to have legal consequences, right? But that's back in Unit 2 on assent. Here, we're talking about whether these types of promises must be in writing, and they don't have to be in writing. All right, the next type of contract that must be within the Statute of Frauds is the executor promise, right? Well, what is the executor promise? So it's when an executor or an administrator of an estate, a decedent's estate, someone has passed away and we have an executor or an administrator of her estate, and that executor or administrator promises to pay the decedent's debts, the estate's debts, out of the executor's own pocket. Right? So here's one thing that you might be confused about. Remember, when you die, your debts don't die with you. Your estate is still responsible for those debts. So let's talk about the difference between an executor and an administrator. If you die without a will, if you die with a will and you appoint an executor of your estate, then you'll have an executor. If you die without a will, or if you die with a will and you don't appoint an executor, then the person who executes your estate, who takes care of it, who administrates your estate, that is the administrator of your estate. So just different phrases. The person is doing effectively the same job. So why would an executor or an administrator promise to pay the debts of the estate out of her own pocket? Well, probably because she's a beneficiary of the estate. So let's assume my aunt passes away and she leaves me a house, and I'm an executor of her estate. But she has other debts, and the only way that the estate can pay the debts is by selling that house. But I want that house. I want to live in that house. So I promise to pay the debt of the estate out of my own pocket, so I don't have to sell the house as the executor, so that the estate can meet the debt. That's probably the situation we're talking about. It's pretty easy to spot as soon as you see an executor or administrator of someone's estate and they make a promise. That promise must be in writing. If it's not in writing, it's not enforceable. Right? What's the language we use? It's within the Statute of Frauds. This type of contract is within the Statute of Frauds, so it must be in writing.